Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
Are you ready?
We are indeed.
Yes.
Chair, our first witness this morning is Mr. Pamensky. He is legally represented, so if I may just ask for an opportunity for his legal representative to introduce themselves.
Yes, thank you. Just
Thank you. Good morning, Chair.
please
Jonathan.
come forward. Yes. Thank you. You did, of course, introduce yourself yesterday, just to place yourselves on
Yes.
record.
Morning, Chair. My name is
Good
Jonathan
morning.
Blow. I'm
Yes.
counsel from Johannesburg Bar, briefed by Attorney Adam Mitchell, representing Mr. Pamensky.
Thank you very much.
Thank you.
Thank you.
And Chair, no other lawyers have introduced themselves to me this morning, but I know from correspondence
Yes.
that one or two of the implicated persons indicated that they might have lawyers present.
Yes,
So
yes.
maybe we should just give an opportunity if there is
Well,
anyone.
nobody is rising,
No.
so I'm sure they are not in the room.
That's fine.
Okay.
Thank you. Chairperson, if we may then just proceed to
Yes.
swear the witness in. We're ready
Yeah.
to commence.
Okay, please do that.
Please state your full names for the record.
Mark Vivian Pamensky.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you give will be the truth, the whole truth and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may
Thank you, Chair.
start. Yes.
Mr. Pamensky, just to give you some assistance as to the files and everything that's around you, you have a file in front of you. Chair, if we can enter Mr. Pamensky's affidavit and annexures into the record as Exhibit MM3.
The lever arch file containing Mr. Pamensky's affidavit and annexures will be marked as Exhibit MM3.
Thank you. We will work predominantly in that file, Mr. Pamensky, but there will be a few occasions where I'll need to take you to other files, and those are contained in the black box next to you on your left. And then also just to orientate you, the page numbering in the top right-hand corner of the bundle in front of you and all other bundles will be what I'm referring to where I ask you to go to a particular page. And other than that, just to make sure that the microphone stays on and is fairly close to you for the purposes of the evidence. Mr. Pamensky, if we turn up page 1 of the Exhibit MM3 in front of you, that, I understand, is an affidavit you provided to the Commission and was deposed to on the 16th of October. Is that correct?
That's correct.
Thank you. And as I indicated, we'll work predominantly in your affidavit, and on occasion I'll need to take you to other documents, both in this file and in other files. Mr. Pamensky, can you tell us when you joined Iskcon?
I joined Eskom board on the 11th of December 2014.
And until when were you a board member of Iskcon?
Up until 25th or the 26th of November 2016.
Thank you. And during your time at Iskcon, did you serve on any committees?
Yes, ma'am. My first committee was the Investment and Finance Committee, whereby I moved in July 2016 to the Audit and Risk Committee.
And you were there until your resignation in November 2016, is that correct?
That's correct.
Thank you. And could you please tell us what qualifications you hold?
Yes, I'm a chartered accountant.
And other than serving on the board of Iskcon during that period, have you served on other boards of companies?
Yes, roughly at that point in time, about 25 boards of directors.
And were any of those companies state-owned enterprises?
No.
And have there been any state-owned enterprise boards on which you've sat since your departure from Iskcon?
No.
Can you tell us a little bit about how you got to be appointed to the Eskom board in December of 2014?
Yes, in mid-2014, I was planning to move on from Blue Label Telecoms within about a year or two. Roughly about the 28th of September, there was an advert in the Sunday Times newspaper. I duly printed it, scanned it, and filled in the opportunity to apply to become a director on Iskcon. I felt that my skills in relation to turnaround, M&A, and restructuring would be ideal for this environment, specifically the position that Iskcon was in at that point in time.
What was that position?
There were load shedding, there was financial problems, there was cash flow problems and all of that. So those were the high levels that the market was aware of roughly about those dates.
I think at one point in your affidavit you describe Eskom as being in a state of financial disarray. Is that, in your view, an accurate description of it at that time?
That is correct.
And so I have it that you put in the application for the position at Eskom. What happened thereafter?
Subsequent to that application, I received confirmation on the 11th of December that my position to the board of Eskom had been accepted.
And who was that communication from? To assist you, it's under tab 4 of your affidavit, which you'll find at page 44.
It was Miriam Magora from the DPE department.
And as I understand that email, she's attaching a letter from the minister. Is that correct?
Yes,
And it's the minister informing you that you have been chosen for appointment to the board of Eskom. Is that right?
correct.
And what happened thereafter?
Thereafter, I sent a few days later an email to inform them that I'm honored to take this position, but I wanted to inform them of a potential conflict between Blue Label Telecoms and its subsidiary CGCell, which had an electricity prepaid vending contract that was awarded in 2007, and to inform them that if this is going to jeopardize any business or relationship with CGCell, I'd have to consider my options.
And what was the response to that?
There was a series of responses. They wanted to find out more information from me, and I duly replied with some more information.
Let's go there if we may. If you go into your affidavit at page 5, you'll see at paragraph 15.2 on that page, you say on the same day, that's a reference to the 18th of December, Ms. Shelley Pather, the Director of Governance within the Department of Public Enterprises, called you to discuss your directorships and potential conflicts of interest. She followed that call up with an email in which she requested that I provide the department with detailed information of the companies in which I held directors' positions. Do you see that? I'd like to go to that particular response that you provided, if I may, and you'll find that at page 61 under tab 7.
Yes, ma'am.
Can you explain what this page discloses?
This page discloses that the Department of DPE wanted to find out more information in connection with my telephone call and my disclosures and potential perceived conflicts of interest.
So it's headed with your name, and then it says current directorships. And then there's a list of 25. Are those companies of which you were a director at the time?
Yes, or alternative director at the time. They were both local and international companies.
Right. I see the last two are indicated as a position of alternative director, correct?
Correct.
So all the others are non-alternate, full-time directors.
That is correct.
Can we go to number 16 on that page? Which company is that?
Oak Bay Resources and Energy Limited.
And then you have in brackets there not reflecting on SABC. Why was that?
As I understand, CPRC were backlogged, so it took them time to obviously put your records within the CPRC.
When did you become a director of Oak Bay?
I think, I'll stand to correction, but I think it's the 25th of September 2014.
Thank you. Mr. Pamensky, you're very accurate with your dates, and we appreciate that. If you're not certain, September 2014 would be sufficient for our purposes. I'll probe further if I need a particular date.
Understood.
But thank you for that. So that was September 2014. That's the same time that the Sunday Times advertisement appeared for applications to state-owned enterprises. Is that right?
That's correct.
And tell us about how you became a director of Oak Bay.
Well, I was called to a meeting by Mr. Atul Gupta, who explained to me that they are listing a subsidiary of theirs called Oak Bay Resources and Energy, which it had a subsidiary called Shiva Uranium that was involved in the uranium and the gold industry, and they were looking for independent, non-executive directors to join their boards.
Had you had any engagements with Mr. Gupta prior to that?
Not Mr. Atul Gupta, no.
Any of the other Gupta brothers or associates?
Yes, roughly in June, I met Mr. Tony Gupta.
Where?
At his house in Saxonwold.
For what purpose?
Just a general discussion. It was an introduction.
Did you contact him or did he contact you?
No, he contacted me.
Did he explain to you why?
No, he said, would you like to come over and have a cup of tea and have a discussion?
Did you know anything about the purpose of the interaction?
No.
Did you know each other prior to that?
No, I did not.
He just called you out of the blue and then said, would you like to come and have a discussion with me?
Chair, I think it was it could have been a telephone call or it could have been an SMS to say, would you like to come and have a cup of tea, or would you like just to come have a meeting? Like a normal business, you know, people phone people up and said, come have a meeting.
Yes. And your response was to come?
Yes, sir.
Yes. Okay.
And what was the subject matter of that discussion?
It was a general discussion. I explained who I am. I explained what Blue Label does. He explained a little bit of the Sahara Group, a little bit of Shiva Uranium, and just a general chat of the group.
Did he discuss TNA at all?
No, he did not.
You recall that specifically?
Yes, because he focused specifically more on the mining and Sahara computers.
And then, as I understand your evidence, there's a follow-up then in September, but this time not by Mr. Tony Gupta, by Mr. Atul Gupta. Is that correct?
I would assume, I think it was in roughly August, ma'am, where he explained the potential listing of Oak Bay Resources and Energy Limited.
And what was your response to that proposition?
I needed to think about it. I needed to also discuss it with my employer. I need to consider if there's any conflicts and if I'm an independent non-executive within relation to that position.
And in either of these discussions, was your interest in or prospects of becoming an Iskcon board member discussed?
No.
Not at all?
Not at all.
Thank you. If we can then go back to your affidavit at page 5. There we were at paragraph 15.2, and following that in your affidavit, you talk about how your disclosure of these directorships was then resolved with the Department of Public Enterprises. Can you explain that to us, please?
My understanding is I explained the potential perceived conflict together with disclosures, and at the same time updating my directorships.
And how did it all resolve itself?
It resolved itself where I received another email whereby, first I wrote back after that date From the 19th, I wrote back on the 4th of December. I hadn't heard anything. To Ms. Pather, because I'd received an email for the board meetings and the dates for the board meetings. So I did not want to let anyone down, so I wanted to get confirmation that the DP and Iskcon were comfortable with my disclosures, as well as perceived conflicts.
Just tell me about those dates for the board meetings. Were you given a schedule for the year?
I can't remember at that point in time, but normally, and I think it could have happened post that, where you get, I remember in 2016, we got a schedule of all the board meetings and all the committee meetings for the year.
But your urgency, I suspect, would at least have related to knowing when the first board meeting was going to be held. Would you have known that?
Yes, I knew that, but your question, sorry if I'm wrong, was to say, was there the whole schedule for the year? No, I knew there was a board meeting on the 16th.
16th of January 2015.
That's correct.
But you can't recall whether you knew when the remainder in the year were scheduled?
Correct.
If we can then go to page 7 of your affidavit. I have it there that at paragraph 16, there was an acceptance, in essence, that your existing directorships did not interfere with your ability to serve on the board and that there was no impediment to joining the board. Is that correct?
Yes.
Can I just understand, the particular conflict that you raised and you were concerned about was the CG cell one, is that correct?
That is correct.
Was there any interaction at all between you and the department or the minister about your directorship on the Oak Bay board?
No, there was not. At that point in time, Oak Bay Resources and Energy Limited was purely in uranium and gold mining, and it had the normal standard contract for electricity, so there was no conflict at all within that environment.
Thank you. I note that in the portfolio committee's hearings that preceded their report of 2018, Minister Brown gave evidence at the time that your Oak Bay directorship only occurred after you became a member of the board of Eskom. That would have been incorrect, wouldn't it?
Correct.
Thank you. Let's then move to paragraph 17 on page 7, if we may, because you there start to talk about the preparations you undertook. Because as I have it, you've now confirmed your appointment to the board. Can you take us through what preparations you engaged on?
Yes, after acceptance of that appointment post, I started taking steps to understand the business. I went through the audited financial statements for March, the integrated report for March. I also looked up the requirements while I was reading that for the audit, because I'm an accountant. For the PFMA perspective, it explained a few elements. I also looked at the interim results and just generally trying to search the internet to find more information on the business and the role that we're going to take.
Those interim results were the November results, is that right?
They were presented in November, but they were for the 30th of September 2014.
Indeed. And we've touched on it a bit, but I understand part of your rationale for making yourself available for appointment was your understanding of the precarious financial position Eskom was in and your sense that you may be able to contribute to turning it around. Is that a fair summary?
I would say that's a fair summary.
Thank you. Were you aware that in October 2014, Eskom had received a 20 billion rand financial support package from government?
I was aware that they were going to give a 23 billion. I was not aware whether it had been paid or not.
Thank you. And if we go over the page to page 8, you'll see there at the top of the page, paragraph 18, you say there, I did not at that stage read or consider the Public Finance Management Act other than the reporting requirements and was not familiar with it. Do you see that?
I do.
But you go on to explain that you did gain some insight. Can you tell us about that?
Yes, as we progressed in Eskom, I started to obtain more understanding of the PFMA and what the requirements are from a high level. And as you got into the business and you got to understand more down the line, did you get to understand more about the business regime, the PFMA regime, and those items?
Do you think it's important for board members of state-owned enterprises to be familiar with the PFMA?
I do.
Would you agree that the PFMA places heightened obligations on the directors of boards of state-owned enterprises as compared with any ordinary private company?
At what point in time would I have understood that, are you asking me?
Do you agree that it does do that?
I do agree it does.
And do you accept that the reason for that might be that state-owned enterprises are spending public money?
I do agree with that.
I'd like to go to the Public Finance Management Act with you, if I may, because there are particular provisions of it that are relevant to the conduct of the board that we're interested in these proceedings. You'll find a file next to you called a legislation bundle. And we'll start, if we may, at section 50, 50. You'll find that at paginated page 23. So just to be clear, you would not have read the text of this act by about January or February of 2015, would you?
I can't specifically recall, but I did read the specific act, and I did get to understand it within the first 6 months of my directorship.
Okay, so the sections I'm going to take you to then should be relatively familiar to you. If we start at section 50, that sets out fiduciary duties of accounting authorities. In the context of Iskcon, what is the accounting authority of Iskcon?
That would be the board.
And you see there under 1A and 1B, amongst those duties are a duty to exercise the duty of utmost care to ensure reasonable protection of the assets and records of the public entity, and B, to act with fidelity, honesty, integrity, and in the best interests of the public entity in managing the financial affairs of the public entity. So you were aware of those obligations, were you?
I was aware of those obligations.
If we go down to section 51, the accounting authority, again the board of which you were a member, for a public entity must do a series of things, and then there's sub-paragraphs. The ones I'd like to highlight are over the page at 24. So if we start at B, the board of Iskcon, let's just read that in for present purposes, must take effective and appropriate steps. Roman 2 is the one I'm interested in, to prevent irregular expenditure, fruitless and wasteful expenditure. Do you see that?
I see that.
Did you have an understanding of what those terms meant?
I did have an understanding of what those terms meant. As I said to you, when I was preparing for this element, I understood an accounting element that you had to report irregular and wasteful expenditure.
So would you accept wasteful expenditure is expenditure undertaken by a state-owned enterprise for which it does not receive adequate value?
Adequate value or value in vain?
Indeed.
Yes.
I think
Yes.
that's a fair description. And what did you understand by irregular expenditure?
Irregular expenditure is expenditure that is not unauthorized expenditure, but however expenditure that is in contravention of any laws and regulations that pertain to the whole Eskom organization.
Or I suspect a specific area in which the decision is being taken.
Sorry, I'm not understanding.
In your answer, you gave some emphasis to the rules or regulations that govern the whole of Eskom. I was just saying, I suspect it would also be any rules or regulations that apply to a particular division or area within Eskom. Do you accept that?
I accept that.
Thank you. And then if we go to E, further down the page, you'll see the board of Eskom must take effective and appropriate disciplinary steps against any employee of the public entity who, Roman 1, contravenes or fails to comply with a provision of this Act, and the other one I'm interested in is Roman 3, makes or permits an irregular expenditure or fruitless and wasteful expenditure. Do you see that?
I see that, ma'am.
And were you aware of that obligation on the board at the time?
Not at the time. Over time, within the first 6 months, I believe I was aware of these elements within the 6-month period.
Do you accept that this is, on the face of the section, quite clearly an obligation placed on the board to discipline employees who are found to have contravened or otherwise made or permitted irregular or fruitless or wasteful expenditure?
I accept that.
The next section I'd like us to go to is section 83, and you'll find that on page 31. And now section 83 deals with financial misconduct by accounting authorities and officials of public entities. Is this a section you were aware of?
No.
Let's just look at it. Did you come to be aware of it?
Not specifically, according to my memory, can I recall specifically the specific one. I remember the general ones that you've mentioned before and the accounting as well.
Right. Let's look at 83 then.
Sorry, ma'am, may I jump in? Sorry, Chair.
Yes.
Also, at this point in time, you know, we have expertise at Iskcon. We have the CEO, CFO,
Yes.
who should know these items. We have the company secretary, who is an
Yes.
attorney,
Yes.
who know these things, and you can always call on management and the legal team to
Yeah.
assist with any of these
Yes.
as and when they arrive.
Yeah.
Let's look at section 83. It provides that the accounting authority for a public entity commits an act of financial misconduct if that accounting authority willfully or negligently, A, fails to comply with a requirement of sections 50 to 55. Now, you'll recall the section we were in previously was section 51. So there's a link between those two sections. There's financial misconduct if an accounting authority fails to comply with the obligations placed on it under section 51. Do you understand that?
I understand that.
And B is that accounting authority will engage in financial misconduct if it willfully or negligently makes or permits an irregular expenditure or a fruitless and wasteful expenditure. Do you see that?
I see that.
So let's just probe your understanding of that. If an accounting authority took a decision that constituted wasteful expenditure, do you understand section 83 to then make that financial misconduct?
I do.
And subsection 2 says if the accounting authority is a board or other board consisting of, or body consisting of members, every member is individually and severally liable for any financial misconduct of the accounting authority. Do you see that?
I see that.
I want to pause there for a moment because when you indicated to the chair you wanted to say something a bit further a moment or so ago, you made reference to the resources within Eskom that could be relied upon insofar as the obligations of board members is concerned. Is that a fair summary?
That is a fair summary.
Do you accept, however, that if you are a member of a board of a state-owned entity, you should yourself know about the provisions of financial misconduct in the PFMA?
Ma'am, I don't know about PFMA misconduct, but I believe our general principles and those high-level principles that you can read and understand as a board member, you should understand that and take steps to understand that.
Why any reluctance about financial misconduct? It's a provision of the Act that says the accounting authority must not in any way breach the Act or engage itself in irregular, wasteful, or fruitless expenditure, and every member of the board has that obligation. Why is that in any way different to the other provisions?
I'm saying the difference is I remember reading the other provisions. I don't recall going into this financial misconduct.
I fully understand that. I'm asking at the level of principle.
Yes, you're correct on the level of principle.
You should, any member of an accounting authority of an SOE should know about what is required of them in order not to engage in financial misconduct.
Correct.
And 83.4 provides that financial misconduct is a ground for dismissal or suspension of or other sanction against a member or person referred to in 2 or 3 despite any other legislation. Just to be clear, I take it that you'll say at the time you weren't aware of this provision. Is that correct?
That's correct.
Is this the first time you're aware of that provision?
No, this is not the first time I'm aware of that provision.
You became aware of it in the course of your position on the board of Eskom, is that correct?
Yes, from a high level, that financial misconduct is irregular.
Thank you. And I think the important point about 4 is that it can result in sanctions taken against those who are engaged in it. Do you
Correct.
accept that?
I accept that.
Thank you. And then if we go over to the next page, page 32, there's a section that creates offences and penalties. Were you aware of this section at the time you took up the directorship at Eskom?
No, I was not.
Did you subsequently become aware of it?
Don't know, cannot recall.
Okay. Let's look at subsection 2. Because subsection 2 says an accounting authority is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 5 years, if that accounting authority willfully or in a grossly negligent way fails to comply with the provision of sections 50, 51, or 55. So that again is a reference back to those fundamental duties that we looked at in 51, and creates an offence if any accounting authority willfully or grossly negligently fails to comply with its requirements. Do you see that?
I see that.
Thank you. If we can then return to your affidavit, and we'll pick it up at page 8 of the affidavit.
Sorry, ma'am, can I put the file back or leave it on the side?
Yes, you can put the file back. We may need to go to it later, but not imminently.
So can you repeat what page?
Page 8. And at page 8, I'd like to pick it up at paragraph 19, because there you say you attended your first board meeting shortly thereafter on the 16th of January 2015.
Correct.
Do you recall that?
I recall that.
Do you recall whether there were any discussions at that meeting about the TNA contract that had been entered into, signed by Mr. Majila for 43.2 million rand?
No.
I asked a composite question there, which wasn't fair. I said, can you recall whether it was discussed?
There was nothing discussed.
Nothing discussed. Thank you. At the meeting on the 16th of January, were you then alerted to when the next meetings of the board would be?
I cannot recall.
Do you have a sense of how regularly the board was meeting in 2015?
At the beginning of the stage, it was common cause that Eskom was in this financial disarray. There was the war room, there was load shedding, there was a variety of elements. So they were quite active at that point in time. Their subcommittees started getting active from that period, so you'd spend quite a bit of time involved in those committees, specifically the finance committee that I was in.
We've looked at the minutes of the board meetings, and it seems to us that they occurred at least monthly for most of the year of 2015. Does that accord with your recollection?
My recollection was that there was meant to be a board meeting on the 26th of February, and that meeting got cancelled at the last moment.
Okay, but let's talk first of all about the spread of the year. Was there generally a meeting every month?
Of the board?
Yes.
No. The board meetings are set in periods every quarter, and then any ad hoc or any other meetings that need to be adhered to would then be called accordingly.
Okay. And do you have a particular recollection about the 26th of February meeting being postponed? Is that right?
That is correct.
So as you sit here now, are you aware of a meeting on the 16th of February that took place?
I cannot recall exactly.
When it's relevant, we'll take you to the
Thank you.
particular minutes. Okay, so you have this first board meeting on the 16th of January, and I understand you to say there was no discussion at all in that board meeting about the TNA contract that we're interested in at the Commission at the moment. Is that right?
That is correct.
Were there handover reports made available to you at that first meeting?
According to based on my recollection, I do not remember getting any handover reports.
Okay. I want to take you to what we've been able to source as the board pack that was provided for that first meeting. It does appear to have handover reports, but Mr. Pamensky, I fully appreciate we're going back many years now. So what I'd like to do is ask you to look at the document, and then you can tell us whether it jogs a memory. So you'll find that handover, at least the board pack, let me just find it here. Oh, yes, that's where we need to go into another file. If we can please, if you can take out the file of Mr. Tsotsi's evidence, that is marked on its spine, MM6. And in that file, I'd like us to turn up page 317 towards the back. Okay, so that seems to be an agenda for the Eskom Board of Directors meeting to be held on the 16th of January 2015 at Megawatt Park. Mr. Pamensky, to the extent that I take you to documents that you haven't seen for a while and you want an opportunity to consider, you must please indicate to us that you'd like that opportunity at any point. So this appears to be the agenda, and then what is over the page and successive pages thereafter are various documents that we understand to have been included in the board pack that was provided for that meeting. And it's a series of, in a sense, handover reports. The first document at 318 is preparation for board transition. IFC, that's the committee. Had you been appointed to that committee yet, or?
No, I had not been appointed to that committee yet.
Okay. But that would have been the one that you subsequently come to sit on.
Yes.
Is that right? Having seen these documents now, does it jog a memory that these had been provided?
No, Chair, does not.
There's one report here that I'm interested in, and it appears at page 361.
Yes, ma'am.
The relevant text I want to take you to is 361. You don't need to flip back 2 pages, but just to tell you, 2 pages back is the start of this report, and this is the report of the Audit and Risk Subcommittee of Eskom. But at 361, you'll see there's a series of bullets on the far left-hand side under a heading Outstanding Issues. Do you see that?
I see that, ma'am.
And the third bullet on the far left-hand side reads, reportable irregularity identified by the external auditors during the review of the 30 September 2014 interim results. This matter was reported to and dealt with by the board. Do you see that?
I see that.
Do you remember seeing this at the time?
Not at all, ma'am.
If you'd read it at the time, what would it have conveyed to you?
It would have informed me that the reportable, sorry, I just jump back on my understanding of a reportable irregularity.
Please.
A reportable irregularity is when there's an unlawful act or omission by management that the auditors feel will cause financial harm to the business, or if someone is in breach of their their fiduciary duties. Once the auditors report this, they have to report it directly to IRBA, the independent regulatory body of auditors, and they have 30 days. Sorry, the board and the company has 30 days to respond to that reportable irregularity. My reading of this would say the matter was reported to and it was dealt with by that board, so it wasn't coming across to me, but I have not seen this and I was not aware.
Thank you. If we can then go back into your affidavit.
Now put this back.
Indeed.
Thank you.
Mr. Pamensky, I'm now going to take you to a series of minutes of board meetings at which you were not present. So I want to state up front, I'm not suggesting that you would have had any knowledge of what was going on in those board meetings. They are the three board, at the time, they are the three board meetings that occurred in Eskom prior to the appointment of the new board on the 11th of December. It's important, though, that you now at least get some insight into what was happening in the board prior to you becoming a new member of it. And for that purpose, we're going to focus on what was happening in relation to the TNA contract. Okay. So let's start with the meeting that occurred on the 24th of November, 2014, again, prior to you being a member of the board. That is taken as given. And you will find that in your file at page 336.
Yes, ma'am.
You'll see there this document is headed Minutes of the Eskom Board meeting held on 24 November 2014 at Megawatt Park. And just to confirm, you're not present, you're not a member of the board at that time. I don't suggest you read it in detail. What I would like to take you through, though, is if you go over the page to page 337, you'll see under item 5, which is headed Approval of the Agenda, that it was noted that there was only one agenda item, being the approval of the modifications to the Condensed Group Interim Financial Statements for Eskom Holdings for the 6 months ended 30 September 2014. Those are the IFSs that you considered.
That is correct.
Albeit later.
I considered it later. They were released on the 28th of November.
Correct.
The reportable irregularity was defined on the 21st of November.
Correct. And what then continues in this set of minutes, and I don't suggest we read them, I'll summarize for present purposes, is a detailed engagement about this reportable irregularity, what the board was going to do about it, and by reportable irregularity, it's the TNA contract that was entered into by Mr. Majila, the fact that the independent auditors had identified it, the fact that they needed to report on it. So much of what you've said about reportable irregularities was being discussed by the board.
Sorry, ma'am, I'll just say something, Chair. In the interim results on the reportable irregularity, it never mentioned the name TNA. Otherwise, I would have picked it up. It said there was a 43 million rand sponsorship that was irregular and that the board was dealing with these issues, which you duly have to do.
So let's just be clear about what you did pick up. Did you pick up the fact of the reportable irregularity for a contract in the value of 43 million?
That's correct.
You didn't, however, relate it to TNA?
That's correct.
Thank you. So, as I say, 24 November meeting, this is being discussed extensively. There's a debate between the Audit and Risk Committee and the chairperson thereof about what the obligations of Eskom are. I'm just drawing to your attention, it was heavily debated in November prior to you being on the board. Right. It was made clear at page 339, if you'd like to just move to that. and it's under clause 6 on that page, paragraph 6 on that page, that the board was really being informed about the nature of reportable irregularities and how auditors are legally obliged to report them when they are found, and then that there's an opportunity for management to respond within 30 days. You're aware of those obligations, are you not?
Yes, as chartered accountants, we should be aware of those
Indeed.
provisions.
And then, Mr. Pamensky, if we can go to the meeting, the next meeting that was held of the board, you'll find that at page 343. That's a meeting of the 3rd of December 2014, just more than a week before you were appointed as a member of the Eskom board. Again, you were not present, but a prominent item on that agenda, you'll see over the page at 344, under paragraph 7, is the TNA sponsorship legal report. Because at this stage, and I take it you subsequently came to be aware that a legal review was done of this contract, is that correct?
Correct.
So just to situate you in time, the board is now on the 3rd of December. They've received the forensic report that the auditors had done, SNG. That report recommended that lawyers be engaged in
Correct.
order to review it. That's your recollection
That's
of the
my
report.
recollection.
Lawyers had been engaged, and at this 3 December meeting, a representative of Ledwaba Mazwai attorneys who had been engaged for the report is in fact invited and makes presentations to the board. I would like to pick up just on one or two aspects of what was discussed there. You'll find that at 345, just like your comment on something that's in the penultimate paragraph. The penultimate paragraph says it was summarized that the complaint was that Mr. Majila exceeded his authority to approve and sign the TNA contract, and that Mr. Chweyu removed the termination clause against legal advice. It appeared that Mr. Majila was not aware that the termination clause had been removed. It was agreed that it was not the board's responsibility to take action against Mr. Chweyu, as he did not report to the board and was an employee of Iskcon. Do you see that?
I see that.
Do you remember a little while ago we looked at the provisions of the PFMA?
I do.
And there was one provision that said that the board must act against any employee
That is correct.
engaged in irregular, fruitless, or wasteful expenditure. If you'd been present at this meeting, do you think you might have taken issue with that?
If I'd been at Eskom for 3-4 years and I understood the PFMA and with the expertise there, you were clearly duty-bound to issue disciplinary.
Mr. Pamensky, why do you preface it with 3 or 4 years? Shouldn't non-executive members of the boards of state-owned entities know about their obligations from the first day they start?
Yes, you learn and take steps to get it. It's a very detailed document. We are not attorneys, so you read the information that's within your or your experience or expertise, such as your general duties. I, as an accountant, looked at the reporting requirement, but you always can rely on the expertise within the organization, such as your company secretary and head of legal, who are normally in attendance in meetings. If I see here, you have the general manager of legal there. I was not sure Mr. Fenter was qualified as an attorney. I knew that the company that's board secretary, sorry. The company secretary was not in attendance and he should know these items. He's also an attorney by practice, and he should have known these elements and advised the board accordingly.
Thank you. But if you'd been on the board for 3 or 4 years, you might have picked it up.
I might have picked it up.
Let's then go over, if we may, to page 347. I'd like to look at the paragraph sort of after the middle of the page that begins, "It was agreed." Do you see that?
Yes.
So there the following is recorded. "It was agreed that the matter had to be finalized." Just to orientate you, it's the TNA matter that they're still discussing. "It had to be finalized at a meeting to be held on 8 December 2014. In response to a discussion as to whether the contract would be regarded as good or bad, it was agreed that from the standpoint of the financial status of Eskom, the contract could not be regarded as a good contract. However, this could only be resolved once Mr. Majila had made a representation to the board and explained why he, Mr. Majila, was of the opinion that it was a good contract." And then there's advice about the procedure that should be followed. Do you see that?
I do.
I want to check with you whether you have the same understanding as I do of that paragraph. It seems to me that what was agreed is that it was necessary for the board to make a determination as to the value of the contract. Do you agree with that?
Just 1 minute, can I just reread
Of
it?
course.
Sorry. Can you repeat your question, please?
Certainly. When I read that, I understand it to mean that the board understood it needed to make a determination itself as to whether there was value in the contract for Eskom.
Yes.
And do you also agree with me that what the board resolved to do is let Mr. Majila come and give us his account of whether there was good value in the contract or not, and then we'd meet again to make a decision?
I do agree with the element, ma'am, where Mr. Machala, the acting CEO, would have to come and explain why it's a good contract. That is correct, the second part of your sentence there. It's in point 1, 2, 3, 4. Correct. He would
Thank
make
you.
representations of whether there was a good or bad contract, why he felt it was a good contract. The board would deliberate and determine from there.
Indeed. And it's identified that that meeting is going to take place on the 8th of December. Do you see that? At the beginning of that paragraph, it was agreed that the matter had to be finalized at a meeting to be held on the 8th of December.
That's correct.
Well, let's move to that meeting, if we may. It starts at page 349. There's a lot of discussion. Just for reference purposes, we'll go to it in a moment. Mr. Majila's representations were dated the 5th of December. So between these two board meetings, they'd clearly followed the process. Mr. Majila's response had been received on the 5th of December, and then the board meets on the 8th of December. Right.
May I ask a question? Ma'am, in the submission of the round-robin resolution that was submitted to us, that date of I can't pronounce names, sorry, I'm terrible. The acting CEO gave a representation based on the SNG report. That's how I interpreted his representations on that date.
We'll look at it when we go to it, because I know it's a particular set of representations you considered carefully.
Yes.
For present purposes, the date is what's relevant. It's the 5th of December, so it comes between the meeting of the 3rd and the meeting of the 8th. You'll accept that?
I'll accept that. Sorry, ma'am. Sorry, Chair. I'm just saying that I'm unaware of that date or any documentation, and nothing that has come to our attention.
Okay. Well, let's just not leave this hanging. If we go to Mr. Majila's response, which was provided to you with the round-robin resolution, let me just find it. It's in your file. It appears in two places, unfortunately. I'm going to take you to the one I think that you provided. It's at page 174 under tab 19.
Yes, ma'am.
This is the representations of Mr. Majila that you considered. Is that correct?
That is correct.
The only point for present purposes is in that long title in capitals. Its measures must be implemented by the Corporate Affairs Department to ensure that these objectives are achieved for the company's benefit. Representations of the Acting Chief Executive Officer to the draft report compiled by SNG, entitled Review of the Process Undertaken in Awarding the Sponsorship Contract to TNA, dated 5 November 2014. You don't take issue with the fact that this was a document produced on the 5th of December 2014, do you?
Ma'am, it was dated the 5th, but there was another date at the back on the 27th.
Yes.
But my interpretation of that, this was in response to the SNG report.
Yes.
So I'm not sure of which are the dates, but I would agree that this is dated the 5th. It must be this was either completed on this was either in relation to the SNG report dated the 5th, which was dated and signed on the 27th of November.
Mr. Pamensky, I have made an error for which I must apologize. This actually even preceded the 3rd of December meeting. This is all happening in November, so I do apologize. It's dated the 5th of November 2014, but you're absolutely right, is in a sense signed off on the 27th of November 2014, which is even before the 3rd of December meeting. You'll accept that?
I will accept that.
Right. So his representations were available prior to the meeting of the 8th of December, and even so prior to the meeting of the 3rd of December, correct?
Correct.
Right. Let's go back then to page 352, if we may. Those are the minutes of the 8 December meeting. Again, it's a meeting at which the representatives of Ledwaba Mazwai attorneys attended, and there was a great deal of further discussion about the TNA contract and what the responsibilities of the board were. In fairness to the board, they were faced with something of a predicament here because they knew that their term was ending very imminently, right? It was going to end on the 10th of December, and they were deciding how to deal with this reportable irregularity, the SNG report, the legal review. And one of the things I just want to pick up on, if I may, at page 352, is in the second paragraph there, the question of this value, was it a good or a bad contract, was taken up. And what Ms. Latuli stated, it's recorded at the bottom of that paragraph, is that the handover report had to reflect that the board had considered whether or not the contract was a bad one and had concluded that the contract was not good at this time. Do you see that?
I see that.
Now, we did look at the Audit and Risk Committee report a moment ago, one that you don't recall having received, but we looked at what it said about this reportable irregularity. As I read it, it didn't say anything about the board having concluded that it was not a good contract. Do you agree with my reading?
I agree with your reading. This was not disclosed in that handover report that you read out.
As a member of the new board, would you have wanted to know this?
Of course. Excuse me, ma'am. Excuse me, Chair. I think we are duty bound to know it. The chief executive, the CFO, company secretary, and the remaining directors are duty bound to inform us of this information and what transpired.
It's even included at 353 as part of the resolutions coming from that meeting. You'll see under paragraph 2 there, Ledwaba Mazwai attorneys and the company secretary would prepare a summary and final resolution on the discussions and decisions around the New Age sponsorship contract for signing by the chairman of the board and the chairman of the Audit and Risk Committee for inclusion in the handover report to the new board. Do you see that?
I do.
As it so happened, at least on the basis of the documents we've been able to source, it doesn't appear that that happened, does it?
No, not at all.
Thank you. Let's return to your affidavit then, if we may. We were at page 8 of your affidavit, paragraph 20. And it's from paragraph 20 that you talk about your disclosure of interests at the 16 January meeting. But we've already had your evidence that the one thing that certainly wasn't discussed at that meeting was the TNA contract, correct?
Correct.
And then if you go over to page 9, you deal there at paragraph 22 with an aspect that you have already addressed, but I'd like to give you an opportunity to do so again. You indicate at paragraph 22 that when you met with the Commission, you were asked in particular whether you had sought nomination to the Eskom board at the instance of or discussed your appointment with any member of the Gupta family. And what was your answer to that?
No.
Thank you. And then over the page at page 10 is where you start to deal with this contract and your involvement in it. So I'd like to start at paragraph 23 there, if we may. You say, paragraph 23, when I joined the Eskom board, I was aware that the New Age, or TNA, was a newspaper in circulation. You say I was not myself a reader. Did you ever read it?
Yes, they were on all the aeroplanes. So, you know, occasionally when you're on the plane, you would pick it up, maybe a dozen, maybe 2 dozen at best. But I mean, it was all on the aeroplanes when we used to travel.
They were also dropped off at Eskom. Did you ever pick up one there?
No.
Okay. What newspapers did you read?
More the Business Day.
Were you a reader of the Mail and Guardian at all?
No.
There were 2 Mail and Guardian reports in October and November of 2014. I accept that you may not have read them, but I'd like to take you to them if I may. They are in your bundle at page 234. So the first one was published on the 24th of October 2014. It talks about the 43 million rand New Age deal raises eyebrows over the former chief executive's alleged role. And the second paragraph says, Eskom is in an uproar after recently departed interim chief executive Colin Majila allegedly disregarded internal legal advice and approved a budget-busting 43 million New Age business breakfast sponsorship. It goes on and gives details about how there had been a whistleblower report and the clauses had been removed against Eskom's commercial interests, and there was no exit clause as a consequence for Eskom. Is this reporting in the public domain something you were aware of when you took up the position on the board?
No.
There was a further article a month later. You'll find that at page 237. And it's really
Did you say 237?
237, indeed, Chair.
Thank you.
This is a follow-up. It's talking about the allegations of the interim chief executive, Mr. Majila, having disregarded internal legal advice and allegedly approved the budget-busting sponsorship. It talks about board members who've been pushing for Mr. Majila's censure, but they've resisted a last-ditch attempt. This is in the week of the 28th of November, by other board members to prevent the irregularity being disclosed in the interim financial statements. Over the page, there's reporting on the fact that Sizwen Saluba Gobodo in SNG, as we're referring to it, had reported the irregularity. But as I understand your evidence, you were not aware of any of this.
No, I was not.
We can then go back to page 10, if we may, of your affidavit. At paragraph 24 there, you say you'd heard about the TNA business, the breakfast briefings, which you understood to be a forum on the SABC through which stakeholders could be engaged or companies could procure a public platform. Did you ever watch the business briefings?
Pre that time, no, I did not, but it was well publicized.
What was well publicized?
That you knew there was this TNA breakfast and it was on 702 and it was a platform to engage.
Did you know that it was mired in controversy as well?
No, not at all.
Not at all.
Not at all.
So you just were aware that these briefings were going on?
There were these TNA breakfast briefings. You used to know that they were once a month and they were on the breakfast time where it was on SABC too. And most people like myself are either driving to work or at work.
Yes, we have had evidence about the target market of the 49M campaign and whether these business breakfasts were reaching that target market. What was the 49M campaign?
That was a campaign, according to my understanding, which was an energy efficiency campaign, which was to inform the public and the general to save electricity and how to utilize electricity more effectively within the environment. That was my understanding.
Did you have any understanding of its target group?
No, I did not.
You say that you didn't watch the breakfasts prior to your appointment to the board. Does that mean you watched them afterwards?
I watched snippets afterwards, maybe 5-10 minutes, to actually see what was this all about.
Whenabouts was that? Mr. Pamensky, I know you're very keen to find specific dates, so let me help you. What I'm interested in is, had you watched one by the time you gave your decision on the round-robin resolution?
No.
And how long after February 2015 might you have looked at one?
Within 6 months or so.
Was it one where Iskcon was a sponsor or not?
I cannot recall.
So,
But what I do recall, sorry, Chair, what I do recall is I didn't see any banners. I saw the TNA like it was behind, where you had a like a stage, and you had the SABC presenter, and then you had various people talking, and then the public interacting.
so you didn't see any Iskcon
I didn't see
banners?
any Eskom advertising.
And did you make any inquiries at any point about how Eskom's branding was to be advanced at these breakfasts?
No, I did not.
So let me tell you a little bit about what that involved. It involved a 49M logo being placed on that screen that you refer to having been dominated by the TNA. And beyond that, not much else. Is this the first time you're hearing that?
That is correct and very surprising.
There was also an address by the sponsor at the breakfast, sort of 5 minutes at the beginning, but that was an address that was not going to be aired. It was just to the people in the room. Do you think that would have been a useful mechanism for promoting the Eskom 49M brand?
Ma'am, I'm not an expert in that area, but common sense just tells me no, it's just people within that area. You know, I would have assumed that it was the whole of the SABC viewerships would have seen that element.
That was never part of the contract, that would be aired. Did you watch any of Mr. Pretorius's evidence earlier this week before the Commission?
Yes, I did.
And Mr. Treyu's evidence of yesterday and before?
Yes, and when I mean I did, I listened to certain snippets, but that's about it.
You might then be aware, particularly from Mr. Pretorius's evidence, that his ultimate take on the value of these business breakfasts was that they made no financial sense. Do you have any basis on which to dispute that conclusion?
No, I don't.
He queried whether the placing of the 49M logo on the screen was actually having any impact for the campaign. He made a few points there. He said the colors aren't even the Eskom colors. The 49M brand was black and yellow. Eskom is blue and white. He also made the point that their research showed that a lot of people thought 49M was a radio station. If you'd known all of those facts, would you have been skeptical about the utility of this medium to promote the 49M campaign?
Certainly would.
The other point that Mr. Pretorius made in his evidence was that it got increasingly difficult even to fill the tables of attendees at the breakfasts. I need to give you a little bit of insight there. Part of the deal that Eskom got by paying 1.2 million rand per breakfast was that they got 2 free tables of attendees at the breakfasts. But Mr. Pretorius's evidence was it got increasingly difficult to get people to come as attendees because of the controversy surrounding the business breakfasts. If you'd known that, would you have been concerned about the value to Eskom?
Yes, I would obviously be concerned.
He said they were eventually populated by staff members. In Mr. Chweyu's evidence yesterday, he made the point that the SABC was actually involved in another aspect of the 49M campaign. What he explained to us was that there were sessions where the Minister of Public Enterprises would go out on a Saturday and collect a group of people together, make representations to them about the 49M campaign, why it was necessary to conserve electricity, and then SABC would be there covering it and then would track him into the houses of people in the nearby vicinity and watch him change a light bulb to an energy-saving light bulb. And Mr. Chweyu gave us evidence that that was at no cost to Eskom to have that footage by SABC. Again, Mr. Pamensky, if you'd known that that was available to Eskom as a method to get out its 49M message, would you have regarded the 1.2 million in the business breakfasts as a commercial sense for Eskom to engage in?
Ma'am, I'd like to put a pause in that, and when you hear my evidence of my reasoning, I can't determine the value. I'm not an expert in that element, so I can't tell you what I determined the value. I can tell you why I made my decision, because I believed we needed to get commercial value. What that commercial value is, I can't comment, but when we get to that, I'll explain more. Sorry.
Thank you. No, I accept that. I guess what I'm asking you to juxtapose is a detailed engagement with the Minister of Public Enterprises talking about the 49M campaign and encouraging people to take energy-saving steps as one method to get the message out, as compared with a business breakfast where the most exposure Eskom gets is a 49M on a screen behind the presenters. If that's what you're choosing between, and you're spending public money, which do you think you'd choose to spend the money on?
Ma'am, it's a hard question to answer. I'm not an expert in that element. I have no idea how many people are going to look at the minister with those people changing light bulbs, and I have no idea the size of the 49mm. I'm truly an accountant, so I haven't got creativity. My apologies. So I'm not sure I can give you a definitive answer.
Okay. We may have to probe that further when it was the board's obligation to assess the commercial value of entering into the contract.
Yes.
Chair, I note that it is tea time, if it's convenient to take the break.
Yes, let's take the tea adjournment and we'll resume at 11:30. We adjourn.
All rise.
Let's proceed.
Thank you, Chair. Chair, over the tea adjournment, my learned friend who is the legal representative of Mr. Pamensky drew something to my attention, which, in fairness, I do want to clarify with
Yes.
Mr. Pamensky.
Okay.
Mr. Pamensky, when we were dealing with the provisions of the PFMA, you'll have that in the legislation bundle, which you'd put away, and I said we might need to take out again. We were looking at the section involving financial misconduct. You'll recall that.
Yes, ma'am.
Inadvertently, I must say, as I was dealing with Section 83 and reading it out to you, I indicated that the accounting authority for a public entity commits an act of financial misconduct if, and then I understand from my learned friend, I might have jumped straight into sub A and B. The import of me having done that is I did not identify that there is a fault requirement attached to that provision. It's that the accounting authority commits an act of financial misconduct if it willfully or negligently fails in the respects we discussed. And I just want you to be clear on that so that there's no unfairness to you. There is a fault requirement for financial misconduct, and there is also a fault requirement under the offences created in Section 86. Do you understand that?
I understand what you're saying.
Thank you. I would then like to move back into your affidavit at page 10. You'll recall this is the part of your affidavit where you start to get into the details of the New Age contract. And we had been talking about your background to the New Age and the business briefings. And what you go on to discuss at page 25 was the point about the irregular expenditure. 25, paragraph 25 on page 10. And you make the point there, I think you testified about earlier, which is that you would have noticed if the irregular expenditure amount of 43 million had been disclosed in the November 2014 financials insofar as it was linked to TNA. Is that correct?
That's correct. The report said 43 million sponsorship contract.
Right. So we go on at paragraph 26 to your statement there that you first learned that Iskcon had concluded a contract with TNA in respect of the breakfast briefings on 3 February when you received a round-robin resolution. Is that correct?
That is correct.
At that point, did you make the link between the reportable irregularity you'd seen and the fact that this was the contract?
Yes, I did.
Right. Let's then, we'll go to the resolution in a moment, but I'd like to pick up at paragraph 27. Will you read for us the first sentence of that paragraph?
It is understood that the matter is urgent.
Well, it was understood that the matter was urgent.
Correct.
Who was that understood by?
By myself.
So it could have read, I understood that the matter was urgent.
Sorry, I understood the matter was urgent based on the reportable irregularity and the reporting requirements to IRBA.
Now, why would that have been the case? Because the 30 days within which management has to respond had passed by February 2015.
My assumption at that point in time, when I received this resolution, was that the prior board did not deal with it. I assumed they would have got an extension, or they didn't get an extension, therefore we had to deal with it.
Well, why did you make that assumption?
Because a reportable irregularity definitely needs to deal with. You have to, sorry ma'am, with a reportable irregularity you need to reply and you need to determine what the board is doing and what its decision was.
Let's go to the resolution that was circulated to you, if we may. It's at page 144 of Exhibit MM3.
Yes.
Do you accept that this round-robin resolution nowhere refers to the matter being urgent?
Yes, I do.
But despite that, you'd come to some conclusion that it was urgent?
No, ma'am. When I read the SNG report and realized, the SNG report together with the legal report, it was in relation to that reportable irregularity that had to be dealt with, in my mind.
You didn't seek clarification as to whether it had been dealt with in accordance with the 30-day response requirement.
No, I did not, but I believe it was self-explanatory is why we got this information from SNG and the lawyers.
Well, the reasons given don't actually highlight the reportable irregularity, do they?
No, they don't.
So let's look at what was disclosed to you as a summary of the facts. We're at page 144. You first told that there's a contract that's been concluded. Do you see that in paragraph 1?
Yes,
You then are told that there was an audit and risk committee query and there was a review by the external auditors.
that is correct.
You then told that SNG conducted a review and compiled a report, and that's presented to ARC and attached.
Yes, correct.
And that ARC tabled the report at the 8 December board meeting. Do you see that?
I see that, ma'am.
We've looked at the prior minutes, which you would not have been privy to at the time. That report was in fact tabled earlier than the 8th of December. But I'm just indicating that to you. You would not, I take it, have known at the time that that was erroneous.
Correct.
And there's an electronic mail message you were told about, sent to the chairman, raising a number of allegations against 2 board members at the time. You then told that the interim chief executive had submitted representations to the board, clarifying and explaining his rationale for concluding the contract. And then you told that the board has the opportunity to review the representations together with all the documents which are attached to the round-robin resolution regarding the contract. And then this is going to be, in a sense, the text of the resolution, what follows. Is that as you understand this document?
Yes, ma'am.
Okay, can you help me with what that first bullet is saying?
The parties that were involved in the matter are no longer within the sphere of Iskcon.
Let's
In
stop
other
there.
words,
Yes.
both Mr. Chawi and the acting CEO are no longer within Iskcon.
That was false at the time. Did you know that?
No, I did not.
But you understand it to mean Mr. Chweyu and Mr. Majila are no longer with Eskom.
Correct.
Right, let's go on.
Sorry, ma'am, do you want me to read?
Yes, please, the second sentence.
This emanates from the rotation of a former board which took effect on 11 December 2014 and the appointment of a permanent chief executive.
Okay, let's stop there. You see, I struggle with the first sentence because the second sentence says that the reason why the parties aren't involved is because of a rotation of the former board. Now, that can only apply to Mr. Majila, can't it?
That is correct.
So what does the first sentence mean then in the light of the second sentence?
The parties, I broke the sentence up in my mind, the parties were the parties to the SNG report. You had it all about the acting CEO and Mr. Chawi. So those were the parties involved in this transaction.
And they had left the sphere because of a rotation of the board.
I did not read it that way. I read it that the parties had left the sphere of Eskom. The reason why the acting CEO was no longer there is because of the rotation of the board. That's how I read it, ma'am.
So when you were deciding on this resolution, you thought Mr. Chweyu was no longer in the employ of Eskom.
That is correct.
And the last sentence?
The parties involved have divergent views on the specific aspects of the matter, and as such, scarce resources would have to be deployed to bring these contentious matters to finality.
What does that mean, Mr. Pamensky?
In my mind, that means that the acting CEO, in his representations, interpreted the delegation of authority to fall under an investment as opposed to what the auditors and the legal opinion confirmed that it was not, it was a sponsorship.
So is this the same parties, Mr. Majila and Mr. Chweyu?
No, this would purely be the acting CEO.
So then it should have been in the singular.
Ma'am, I'm not good at English, but if you say it should be in the...
Well, we're talking about one person.
I'm talking about one person.
Yes. I have great difficulty with this paragraph, and that's why I'm seeking your guidance on it, because what appears to maybe be Mr. Majila and Mr. Treyu in the first sentence, then is not both of them in the second sentence, because that can only relate to Mr. Majila, and then we back to both of them in the third sentence in a context which just doesn't make sense if you're speaking to both of them.
Ma'am, when I read the opinion, what it shows me is that the parties with a divergent view was the difference between the auditors and the acting CEO on his interpretation of the investment or sponsorship.
Right.
Were those the parties that you thought they were talking about when they said the parties involved are not with Eskom?
When they said
with Eskom.
Yes, the parties are not with Eskom, was my understanding. Mr. Chow and the acting CEO were no longer within the sphere of Eskom, the two gentlemen.
Yeah, which wasn't 100% correct.
Yes, but my understanding there was the parties were always the two people who were in the report. So if the two parties had gone, they both were not there anymore, sir.
Okay.
But the parties by the last sentence become the auditors and Mr. Majila.
That's correct.
The second bullet.
Considering the representations made by the then interim CE, there exists a difference of interpretation regarding the provisions of the company delegation of authority that needs to be reviewed and clarified further in order to close any gaps which may be present.
What was your understanding of that bullet?
My understanding was that Mr. Colin Machala thought it was an investment committee decision and fall within the delegation under the investment criteria, and the auditors then said it was a sponsorship, therefore they must correct it and clarify and fix it up that it actually is a sponsorship.
Well, can we unpack that a little bit? Do you know what the external lawyers thought of Mr. Majila's justification for entering into this contract as an investment?
Yes.
What did they think of that?
They disagreed with it. They agreed with the same interpretation as SNG.
And the internal lawyers of Iskcon, what view did they take of the justification offered by Mr. Majila?
They also did not accept that undertaking, as I understand. That was the one from Mr. Adams.
Correct.
Yes.
So what ambiguity was there?
In Mr. Machila's mind, he must have had ambiguity, but the rest of Eskom and everyone else clarified it.
Exactly. So Mr. Majila, who's now out of Iskcon, is the only person who holds the view that this is an investment.
That is correct.
The internal Iskcon lawyers say there's no justification for that view, correct?
Correct.
The external lawyers say there's no justification for that view, correct?
That is correct.
And SNG says there's no justification for that view.
That is correct.
Why was there any ambiguity that then needed to be cleared up with revisions being made to the delegations of authority?
To make it more specific and clear and put it in writing in there to say this does not fall within an investment environment or something to that effect, ma'am. Clarity is maybe making it more clear in the DOA of the document itself.
Mr. Pamensky.
I'm sorry, can I ask you to repeat that answer? I didn't
Yes,
understand it.
Yes, Chair, sorry. May I just ask her to repeat the question so I get my chain of thought again, sorry.
Okay.
Certainly. That will require me to remember the question.
I'll help you if you need help.
No. Thank you, Chair. I'm indebted. The question was, if all the lawyers around the table agreed that there was no ambiguity in the delegation of authority and that Mr. Majila was simply wrong, why did anything have to be done to clear this up?
Oh, so in future these problems don't arise. So in other words, if it's not an investment decision, you need to write it in that delegation of authority that these issues don't arise again. My interpretation of that is, he may not be a lawyer, he may not be an accountant, so you need to make it clear for the incoming or the new CEO and the delegations going forward that clearly defines that a sponsorship does not fall within an investment criteria.
But to justify clarifying that for the future, the board would have had to take the view that although the lawyers and SNG disagreed with Mr. Majila's interpretation. His interpretation could be right or was understandable. It was not just completely out, if you know what I mean. Otherwise, if you have a look and you say, look, it's quite clear, we don't know why he thinks there is justification, then there's no need to put in anything for the future.
No, Chair, his representations were very convincing on how he interpreted
Yes.
the investment committee.
Yes.
So I felt that needed to be cleared up and
Yes.
actually written in the DOA so no one come back and misinterpret what a corporate social responsibility sponsorship is about.
Okay, I think that's important because it speaks to what I'm saying. In other words, speaking for yourself, you say, even though you may have disagreed with his interpretation, you understood where he was coming from with his interpretation, and you could understand maybe how he might have adopted that interpretation. You just didn't want then somebody else to adopt the same interpretation for the future.
That is correct, Chair.
So you're not dismissing it completely as madness.
No, not at all. It was a very compelling, when I read it, was very compelling discussion why he interpreted of investment. I didn't agree with it.
Yes.
And therefore, I wanted to make sure, as it was in the resolution, that this problem does not arise again. So it's clearly defined.
Okay. Well, was that do you know whether some members of the board had the same understanding towards his interpretation as yourself, or is that something you don't know?
Chair, I never spoke to any of the board members, so I
Yes,
don't
okay.
know.
Okay.
Mr. Pamensky, I understand from your affidavit that you never actually got a copy of the third contract that was entered into, that you were being asked to ratify. Is that correct?
That is correct.
My learned friend is going to find us a copy of it. It is in the Pretorius bundle, and that is MM1A. It's the first of his bundles.
Sorry, what page, ma'am?
At page 193.
Sorry, Chair.
193. Do you think you should have seen the agreement that you were being asked to ratify before ratifying it?
No, ma'am, I don't.
Why not?
Ma'am, the annexures were not attached to the documentation, and the evidence was in the SNG report, which came to the conclusion clearly that Mr. Machar, the acting CEO, was in breach of it was in contravention of the delegation of authority. The lawyers too did not read this TNA contract, and they were happy to give their opinion to us, so I had the same comfort from that, ma'am.
Well, they were put under extreme demands of urgency in producing their report. And as I understand their report, that is part of the explanation given for not having had a chance to look at the agreement. Do you accept that?
I accept that, but they still came to they still gave a conclusion and an opinion. They were comfortable to give that opinion without seeing these contracts.
Yes. Mr. Pamensky, they were not the board of Eskom, though, who had various duties under the PFMA and otherwise, and was asked to decide whether to ratify a contract for 43 million rand. Is it your evidence that you don't think it was necessary for the board to see the agreement they were being asked to ratify before they took that decision?
Yes, it is, ma'am.
Well, that's very surprising to me, Mr. Pamensky.
Chair, when I explain my mindset when we get to how I came to this decision,
Yes.
I think it will overcome that
Whatever.
question.
Yes.
Number one, and number two, I'm not a lawyer, Chair, so for me to read something with breach clauses and all of that,
Yeah.
would be more to the lawyers than myself, Chair.
Yes. No, that's fine. Maybe we'll talk further when we come to that point. But I would think that if you are asked to ratify a contract, you must have the contract in front of you. I'm happy to say maybe there may be exceptional circumstances where maybe somebody might be justified in ratifying without seeing, provided certain conditions are met. I'm not sure, but I would have thought that if a board was asked to ratify anything, every member would say, I need to see what I'm ratifying. But maybe we can deal with it at a later time, but Mr. Hofmeyer might be wishing to deal with it now.
Thank you, Chair. Well, let's just go to the contract because I think it would have been useful to have seen at the time. It starts at page 193, as I said, of Exhibit MM1A. And if you go over the page to page 194, it seems to me it might have been useful for the members of the board to have read clauses 2 and 3 of this contract, because clause 2 says, Eskom wishes to participate in the aims and objectives of the TNA Media Limited through the sponsorship of the business briefings. Clause 3, the parties have agreed on the terms and conditions applicable to such sponsorship, which agreement the parties wish to record in writing. Mr. Pamensky, do you think this contract is about sponsorships when you read those two clauses?
Yes, I do, ma'am.
And Mr. Majila was the signatory to this contract, wasn't he?
The SNG opinion said he was the signatory, yes.
Correct. And the reason I raise this is because of the earlier point. Was there any substance at all in Mr. Majila's contention that this was an investment, if the opening two clauses of this agreement say it's a sponsorship?
The conclusion was drawn by the attorneys and by the auditors that this was not a sponsorship agreement. It was quite clear.
Indeed.
It also said, they mentioned the contract, if I recall, in the SNG, where they say this is a sponsorship, not an investment.
Mr. Pamensky, let me explain why I place some significance on this.
Well, Ms. Hofmeyer, I think Mr. Pamensky might not have understood your question. I think her question, Mr. Pamensky, is whether, given the fact that this is what these clauses say, and it's clear it's a sponsorship, and given the fact that Mr. Majila signed this agreement, would there be any basis for anybody to say his interpretation that this was an investment makes sense? You had not seen the agreement.
No, Chair.
Yes.
I never ever said that his interpretation made sense, but he made a compelling argument why he found it an investment and why I felt that you need to make sure going forward that this problem doesn't occur again. I didn't say I agreed with his opinion, Chair, sorry.
Well, Mr. Pamensky, I thought what you said was you did not agree with his interpretation, but when you read what he had to say about his interpretation, he made a compelling case. Now, I'm not sure whether a compelling case is not a case where you say it makes some sense.
Sorry, Chair. His argument, in word compelling, his argument made sense to me how he interpreted as an investment in his mind, but I didn't buy it. Therefore, his argument was compelling how his mind was thinking what this investment is and how he interpreted as an investment, but I did not agree with it, nor did the auditors in that. So all I'm trying to say was we needed to make sure that the future people don't go and have a similar interpretation to what he had.
I think what Ms. Hofmeyer sought to establish from you was whether you would say there was sense in Mr. Majila's interpretation, given the two facts that I referred to earlier, given the clauses that make it clear it's a sponsorship and the fact that he was a signatory to the agreement, whether you say there was sense in his interpretation.
Yes, I do think there was sense in his interpretation because he said the contract did say sponsorship, but his interpretation, if I remember, had to do with an investment and it was getting value out of that contract. So he took a different word and he said, yes, it said sponsorship, but he interpreted it the other way, Chair.
Okay, I don't know if I helped.
You did indeed, Chair. Thank you so much.
Sorry, Chair, sorry, ma'am.
No, not at all. Let me just clarify your evidence, because a moment ago you said, I didn't buy it.
Yes, I didn't buy his interpretation that it was fall under investment because that was a sponsorship element that was applicable for a sponsorship.
So is it fair to say you were skeptical about his justification?
Yes, I'd say I was skeptical about his
If you didn't buy it,
yes, I was skeptical,
You were skeptical.
about it, but it was reasonable in my mind how he made that interpretation, but I did not buy it.
Mr. Pamensky, let's go back to page 145, if we may.
Of which bundle?
Apologies, Chair. We're back in Mr. Pamensky's bundle, MM3.
Can I close this, ma'am?
For now, yes. There's a last bullet on page 145, and again, I'd like you to take me through what that bullet means.
Ma'am, is that the cost and time?
Yes, correct?
The cost and time required to pursue this matter in contrast with matters facing Eskom and the board. The company finds itself in a highly challenging phase of its existence. In light of this, the company resources need to be dedicated to issues which have immediate and fundamental bearing on the reputation and business risks which may accrue to Eskom in the event of the matter continually unresolved.
Okay, let's stop there. What did you understand that to be saying?
The cost and time to pursue this matter in terms of the legal element would not justify the cost and time right now on the position that Eskom was within that environment at that point in time.
So would it be fair to say it's trying to get across that Eskom is in a difficult financial position?
That is what it's saying, ma'am.
And in the context of that position, it needs to resolve this matter. Is that right?
Ma'am, not just in the financial, but within the business as a whole, the operations, the maintenance, the load shedding, with all of that in contrast and it was facing the company at that point in time, not just financial.
I'd like to pick up on the reference to reputational risk. Do you see that? It says the company's resources need to be dedicated to issues which have an immediate and fundamental bearing on the reputational and business risk which may accrue to Eskom in the event of the matter continuing unresolved. So that reference to reputational risk there, did you give any consideration to the reputational risk to Eskom of ratifying this contract?
Yes, that was no, excuse me, ma'am. In my interpretation here of the reputational risk was that if you did not ratify this type of contract, you can land into a position where you're going to have a fight with the CEO, you're going to have a fight with TNA when there's a binding contract, so people will look at you and say, well, hold on, you know, you guys don't abide by contracts. There's also the reputational risk of the audit, and if you don't resolve this issue, how are you going to raise money? So that's how I interpret it in my head.
So you weren't concerned about further entrenching the relationship between Eskom and TNA as a consequence of the board ratifying this contract?
Sorry, ma'am, can you just maybe rephrase that? Sorry.
You've identified the types of reputational risks that you were concerned about. I'm just seeking clarity that it wasn't a concern of yours that by ratifying this contract, Eskom might have damaged its reputation. Because by that stage, the engagements between state-owned enterprises and TNA for these business breakfasts was being criticized in the public domain. Did that not worry you?
Ma'am, I was not aware that it was being criticised in the public domain, therefore it did not apply to my mind in the question that you're asking me, sorry.
So can I clarify, you weren't aware that by this stage, Eskom had been required to respond to a number of parliamentary questions over its involvement with TNA and the business breakfasts?
No, I was not.
Can I take it also that you weren't aware that at this stage the public protector had been investigating the matter and had raised serious concerns about the relationship between all state-owned enterprises and TNA?
No, I was not, ma'am.
Had you known those, would you have given this more thought?
Definitely, ma'am, if I'd known those elements.
Well, this was in 2015, is that right?
Sorry, Chair, the end of
This one.
yes, beginning of 2015, correct.
Beginning of 2015. This was 2 years, or let me say, you knew at the time that TNA was owned by the Gupta family or their companies.
Yes, that is correct.
You did know. You and the board at the time would have been aware, would you not have been, of the waterproof landing which happened in 2013.
Yes, I was aware at that time.
And you and the board and other board members would have been aware of the big noise that that waterproof landing created in the country, and that it was related to the Gupta family.
Yes, I did, Chair.
Were you not concerned about entering or ratifying a contract relating to a Gupta entity in 2015 at a time when all of these things had happened, and already there was a huge concern about the role of the Gupta family in SOEs and the running of the country?
No, Chair, it didn't cross my mind at that point.
Yes.
It didn't cross my mind at that point, and also at that point in time, the Guptas were not so toxic as they are now, Chair, so it didn't cross my mind, that element.
Well, you might wish just to reflect a bit whether you are correct in your assessment of what the situation with the Guptas was in 2015. Of course, it may be that from a certain time after 2015, the awareness of people in the country heightened about the Guptas. But 2015, you might have a different impression, but I think that someone like you would be familiar with what's happening in the country in terms of the newspapers and the media. I'm under the impression that already at that time there was quite a serious concern in the whole country about the role of the Guptas, particularly after the waterproof landing. Is your recollection different?
Chair, my recollection is very different to that. You know, I took the waterproof basis, and I didn't see it in that sense. I really do not see it as toxic that they are today what they were at that point in time.
Okay, thank you.
And then if we can look at the paragraph under the bullet that we've just been dealing with at page 145, it reads, the board recognizes that there's value in platforms that enable Eskom to interact with the public, to communicate and garner support for the work that it is doing, to ensure that South Africa has sufficient energy. In this regard, the contract provides an opportunity for Eskom to achieve the aforesaid objectives. What did you make of that paragraph?
I made of that paragraph that the author of this resolution, together with management, believed that there was value in the platforms that Eskom was going to interact on.
Why did you form that impression from this paragraph? I'll explain why I asked that question. It doesn't say anything in this paragraph about, well, we're going to be spending 43 million and there's a commensurate value that we receive for that 43 million. It does no cost-benefit analysis. Do you agree?
I agree. Ma'am, my thing is the value of the platforms, I couldn't say financially, but there is value within that environment. The board recognizes there's value within the TNA breakfast arena. What that value is something different.
Yes, because in order for you to sign on to this resolution, you would have had to have been persuaded by that, wouldn't you?
To do with value?
Yes.
It would have been an element of my consideration, ma'am.
But at this point in time, you have not seen a business briefing, have you?
No, I have not.
So why would you regard this analysis of value as reflected in these 4 lines as being adequate?
No, I never said it was adequate, ma'am, at all. I just said that the author came across here and said there are value within these platforms to engage stakeholders.
So did you form an independent assessment of value?
Yes, I did, ma'am.
Right. I take it from your affidavit that was based on what Mr. Magilla said.
That was one element of Mr. Magilla said, ma'am.
Then let's go to that shortly. I just want to look at the resolutions recorded on that page. The one I'm interested in is the 3rd one, because amongst the things that were decided to be resolved was that the Corporate Affairs Department is hereby instructed to ensure that maximum value is realized from the contract and must report to the board on measures it will implement to achieve this objective. Do you see that?
I see that, ma'am.
Did you ever receive those reports?
No, I did not.
Did you ask for them?
No, I did not.
Why not?
It must have slipped my mind. I don't think at that point in time my concentration was on this. There was a lot going on within Eskom, but it didn't cross my mind. It would have, no, it didn't cross my mind.
Do you think it should have?
Certainly.
Thank you.
Well, let's talk about this value issue. Isn't the position that when asked to ratify this contract, one of the things you would have looked at is what are the cost implications for Eskom if we ratify this contract? And are those cost implications justified by what Eskom is going to get out of this contract? Am I right to say that should have been and would have been an important factor?
It would have been a very important factor to see
Yes.
what you get out of this contract,
Yes.
most definitely, Chair.
Yes. Now, the point that Ms. Hofmeerman raised about there being no reference, I think, to the 43 million in that paragraph is something that also I was concerned about, because just to talk about value in general doesn't seem to me to be helpful. You've got to say, in the context of what you were asked to do here, you've got to say value in relation to what? And for me, a value in relation to 43 million rand.
So,
And I've got to arrive at a conclusion that the value that Eskom is going to get out of this contract justifies Eskom spending 43 million rand. That's what my thinking would be. Do you want to say something about it?
yes, Chair, and I may be transgressing on a little bit further, but my
Yes.
interpretation of the ratification was that if we, and we'll go into more detail, but
Yes.
if we did not ratify and we cancelled, so we didn't ratify, it would be a repudiation, and TNA would cancel the agreement based on the repudiation and claim damages for 43 million. Instead of us getting 1 cent of value, the attorneys went even further, and let me just quickly read it to you, sir. So to explain to
Yes,
you my
that's fine.
mindset,
Yes,
because
yeah.
my mindset was to claw back as much as possible.
Yeah, that's fine.
So, sorry, ma'am, I'll go there.
Yes, you may go
Okay.
there. You may go there.
So, sir, in the legal opinion, on the two choices that Ledwaba Mazwai said, you're faced with two choices, either ratify or not ratify. In the terms of not ratifying, it said two different clauses. The board determines the decision not to ratify will tantamount to cancellation, and there was no lawful basis to cancel because that termination clause had been out, and TNA could cancel on that contract. And it went on to another clause, clause 4.2.1, and this was quite clear in my head. Except the repudiation leading to termination of the TNA contract, which would entitle TNA to recover damages it would lose as a result of the repudiation, which is likely to equal, open brackets, or close to equaling, close brackets, the unpaid balance of the 43 million contract value, thereby placing Iskcon in the same financial position as if it had ratified the TNA contract, but without any sponsorship associated benefits it would have received from that contract had it not been terminated. So in other words, we were faced as a board with a decision that was taken by a prior board. It came to us. In my mindset was, you needed to ratify this to get the most value out of that contract. What was that value? Chair, I'm an accountant, I don't know those things, but I knew that I'd rather get 20, 30, 40 million rand value as opposed to losing 43 million and not getting anything. So my mindset was to claw back as much value as you can possibly get. So that was my interpretation, sorry.
Okay.
Thank you, Mr. Pamensky. We'll go into that in some greater detail in due course. Just to complete on, we've completed the resolution on its face, so let's go back to your affidavit if we may, and pick it up at the bottom of page 11. We're in Exhibit MM3.
Sorry, yes, ma'am.
So at the bottom of page 11, you say there at paragraph 29 that you got a series of documents. Those are listed above in paragraph 28, and they are documents that I'll take you to now. But just for the record, to be clear, there was the draft round-robin resolution. That's the document we've just been looking at, correct?
Correct, ma'am.
And then you also got the report prepared by SNG, dated 6 November. That was the review of the process undertaken in awarding the sponsorship contract to TNA Media.
That is correct.
You got a legal opinion prepared by Ledwaba Mazwai, setting out their recommendations on the TNA review report, dated 4 December. And you received representations prepared by the then acting CEO, Mr. Majila, in response to SNG's draft report, dated 5 November 2014.
Correct.
And then you go on at 29 and you say, the documents speak for themselves. I do not set out their content fully here. I carefully considered the content of each of them at the time. Is that so?
That is correct, ma'am.
And then we go over the page to 12. I'd like to jump to paragraph 30.3, because in this paragraph you're describing what you understood from the documents. 30.3 reads, pursuant to the recommendations in the SNG report, Eskom had procured urgent legal advice from Ledwaba Mazwai. I want to take the next sentence and break it up if we may. The first thing that you record that they had found is that there was no impropriety in the conclusion of the TNA agreement. Do you see that?
I see that.
What did you mean when you said no impropriety?
There was no criminal intent, there was no fraud, there was no bribery. That's how I interpret it in that sense.
Do you accept that they'd found that he'd acted unlawfully?
Yes, he had.
Do you accept that they'd found that he'd engaged in financial misconduct?
The report said so, yes.
But that wasn't relevant, or was it?
No, ma'am, in my mind, no impropriety was the fraud or corruption or anything to that element.
So was it relevant to you that the lawyers had concluded he had engaged in financial misconduct?
Yes, it was of concern to me.
Was that another reason to be skeptical about Mr. Majila's representations?
Certainly.
Let's then go to the second part of that sentence. You say the second thing that they did is advised that the board had two alternatives available to it. Either to ratify the agreement and procure commercial value from it, or not to ratify it. Do you see that?
Yes, I do.
Can I say, Mr. Pamensky, in fairness to you, that is very consistent with the testimony you've just given. And I want to say that in the following respect. The chairperson asked you questions about value, right? How did you determine whether there was value in the spend of those 43 million rands by Eskom? As I understood your answer, you didn't actually answer how Eskom would get value out of its 43 million spent with TNA as opposed to elsewhere. I understood your answer to be, no, the value equation was get something out of this agreement at all, or get nothing, because if we cancel it, it will be regarded as a repudiation and we'll be on the line for the full total plus probably legal costs. Is that a fair summary of your mindset?
No, with an addition, ma'am, with an addition that on the resolution, I made it clear that you would try and maximize and get the maximum value. So that corporate department was there to get the maximum value out of that 43.
Despite the fact that there was never any follow-up with them as to whether they'd done that.
That's correct.
Of course, I take it that you didn't know what value may have been there to be maximized.
Yes, I wasn't led to believe, but as I said to you, Chair, I really think we were in a hard place, you know.
Yes.
Try to get something out than losing 43 million was
Yes.
my whole concern in that element.
Yes.
I want to probe a bit further your understanding of Ledwaba Mazwai's advice. Because in this paragraph, you're describing, as I understand it, what they advised. They advised that there were these two alternatives, right? And you actually, at the bottom of that paragraph, give us a reference to the particular paragraph where you say they gave this option, in a sense, to the board. Is that right?
Yes, ma'am.
Okay, let's go to that paragraph, if we may. You'll find it at page 190 of the same bundle, MM3.
Yes, ma'am.
So let's pick it up at paragraph 4.1.3.2, because that's the lead-in to the paragraph that you referred us to a moment ago, right? It says there, any ratification of the TNA contract by the Eskom Board of Directors would, in our view, be predicated on one or both of the following primary considerations, namely, I just want to pause there. You, in your testimony a moment ago, jumped to the second one. I'd like us to pause on the first one. The first one says, if the board determines or considers from a commercial perspective that the TNA contract represents good value for money proposition to Eskom, as measured against the costs of the sponsorship on the one hand and the benefits to be derived therefrom by Eskom on the other, and then it goes into the second sub-paragraph that you were drawing our attention to a moment ago. I want to focus on that first one. As I read that first paragraph, it is saying to the Eskom board, when you make this decision whether to ratify this contract or not, you need to determine whether there is commercial value in this contract. Do you have the same understanding of that paragraph?
Yes, there has to be value in the TNA sponsorship elements.
Indeed, and it's not just some value. They're quite specific. It's the cost-benefit analysis that any prudent spender of 43 million rand of public funds would engage in. It's how much you're going to pay for what you're going to get. It's not done in a vacuum, is it?
No, it's not. Is that they saying what you're saying?
Indeed. They go on at 4.1.4 on that page to say, we are not able to offer any advice regarding the commercial value to Eskom of the TNA contract. I read that to say, you have to look elsewhere, Board of Eskom, to determine this commercial value, which they regard as a prerequisite to any ratification decision by the board. Do you have the same understanding?
So can you just repeat that question again?
What 4.1.4 conveys to me, if I was the reader of this, being asked to sign on to the round-robin resolution, is that Ledwaba Mazwai, the authors of this report, can't offer advice as to the commercial value to Eskom of the TNA contract. Do you understand it?
I agree with that.
But earlier, we've established that those same lawyers said it's relevant to your ratification decision, Board of Eskom, that you determine whether there is commercial value in the TNA contract, correct?
Ma'am, that's what they said, and my interpretation is going back. Again, as I said, we're in that position where we found ourselves with a contract that's signed. My fear was to lose 43 million and not obtain one sponsor or corporate value as they explained to us over here. So I felt it was in the best interests of Eskom to procure value. There had to be some value because Colin Machila explained his value and made sure you claw as much value possible as opposed to losing it. So, it was a hard question at my point in that time to determine, do we lose 43 or do we try to claw back as much as possible?
Mr. Pamensky, I understand that was your interpretation. What I'm seeking to do now is explore the reasonableness of that interpretation.
I got you, ma'am.
Do you agree that the lawyers were saying the Board of Eskom has to determine whether there is commercial value in this contract?
Sorry, Chair, if I may interject for a moment.
Yeah.
And maybe...
Please come forward.
Sorry.
Yeah.
And perhaps it's better for the witness to just leave the room, because I don't want to be accused later of my answer of my objection putting questions into his mind.
Yes. Okay, Mr. Pamensky, can we excuse you for a minute? Somebody will call you from outside.
We are dealing with, on any version, a layperson here who's not the author of the document. It's established law that documents bear an ordinary meaning in an objective sense. Their proper meaning is not what he thinks, it's not what Ms. Hofmeyer thinks, it's not even with respect to what you think. Documents ought to be construed purposively in context and having regard to their words. So although it's quite permissible, of course, for this commission to interrogate Mr. Pamensky's state of mind in ratifying the contract and what he understood something to be, and also to the reasonableness of such a belief in the light of the words, it is important, I'm afraid, to have to point out that in this document at 4.1.3.2, the authors, the lawyers were saying it can be predicated on one or both. And it says and or. So either you can decide, as I understand this, that this represents good value just without any fear of the consequences of cancellation. You may just define that despite the fact that it's irregular expenditure and financial misconduct, that it is a contract that's worthwhile having independently of any consequences relating to cancellation. It says and or, if the board determines that a decision to ratify is tantamount to cancellation where there are no grounds, then it would result in a claim for damages. The only point I'm trying to make is it wasn't meant to be necessarily a combined understanding. The witness's evidence was that he placed more weight, rightly or wrongly, on 41322 because some value is better than none. But I don't think it's fair to put to him that the authors of this document meant there had to always be a positive answer to one before you could go into two and ratify the contract. I'm just putting that on the record. That's my reading of the document, and I think it's ultimately one can argue and deal with it at the end.
Yes,
But
yes.
I don't think it can be put categorically that it was a sine qua non to the board's decision, because it's not the way I read it.
Yes, okay, no, I understand your point. Ms. Hofmeyer?
Thank you, Chair. Mr. Pamensky's affidavit before this commission and his evidence today says that he came to the decision to ratify the contract based on what was in these documents. It's my submission that it is therefore fair to probe with him what his understanding of the documents was. Mr. Pamensky's answer, in fairness to him, about clause 4.1.3.2.1 was that it was necessary to establish whether there was commercial value. Mr. Blow, acting for Mr. Pamensky, places greater emphasis on the second clause. Mr. Pamensky is fully entitled to give that answer when I seek to probe with him whether it was his understanding that commercial value was an aspect that the board itself had to determine. So it's my submission that we leave it to Mr. Pamensky to answer that. I'm suggesting that His understanding of this document is absolutely key to the decision that he took and the question whether that decision was lawfully taken given the requirements of the PFMA that we've been through previously. It's in that context that I ask the questions.
Okay, I think, yeah, okay. Maybe let me tell you what I was thinking of saying before you.
Yes, thank you.
It seems to me that it's how the question is put to him that's important.
Yes.
And now that you have raised your concern, I think Ms. Hofmeyr is alive to it.
Yes.
And there's good chance that going forward,
Yes.
she will put it in such a way that
That it's more neutral.
Yeah,
Can I just say, that's the
yes.
only thing I wanted to place on record. It's one thing to say to a witness, read the clause and give me what your understanding was at the time. It's quite something else to say to the witness, I read the clause as a senior lawyer in the following way, would you agree? It's very difficult for him to say that he thinks it has a different meaning. If you want to know what his understanding was, ask his understanding.
Well, I'm not sure about the latter part,
but-
particularly where we're dealing with somebody who is a chartered accountant. But
No, the
I
only
think
point I'm making is
they should be able to say, no, that's not how I read it.
I have no difficulty.
Yes.
But the point is, I don't think the examiner can rightly say, it must be read in this way, or as I read it in this way. That's what I'm saying.
Yeah, no.
I think the point's been made, and I think it's just...
Yeah, no, I think
If
Ms.
the question is
Hofmeyr.
asked in a bit of a more neutral way, then perhaps
Yes,
we won't
no,
have any further difficulty.
that's fine. I'm sure
Thank you,
it will be sorted out, yeah. Thank you. Mr. Pamensky must be called back now. I think it's, yeah. Thank you, Mr. Pamensky. Yes.
Ma'am, must I say also something here, please? This resolution was, had the CEO and CFO on there. You know, they would have voiced, and they're duty bound to voice their opinions if they also didn't feel there was value in the specific contract.
How were they going to do that?
They could have called us. They could have written on the email. There are a variety of ways to communicate with us.
Thank you. We'll return to the question of this decision. Oh, goodness. We
Sorry,
seem
Chair.
to have
Sorry, Chair.
had an accident.
Okay, somebody will assist you, and they'll give you another glass.
Sorry, Chair, sorry.
Thankfully, it wasn't a mirror.
Sorry.
Yes, thank you.
Thank you, Chair. Mr. Pamensky, if we can then go to page 13 of the affidavit, because I think it's useful to use your own words from your affidavit in order to take further this debate we're having about the commercial value in the contract with TNA.
Yes, ma'am.
At paragraph 32, you say, my view that ratifying the contract as opposed to repudiating it made good commercial sense was based inter alia on the following information set forth in Mr. Majila's representations in response to the SNG report, which accompanied the draft round-robin resolution. Let's just pause there. Is it a fair reading of that paragraph to say you did understand that you needed to make an inquiry into the commercial sense of the contract?
The
Sorry,
commercial
Nancy.
value.
The
Ca-
commercial value.
Sorry, can you just repeat your question?
I want to just establish whether you and I understand this paragraph of your affidavit in the same way. I understand it to be saying you understood that you needed to determine as a member of
No,
this
ma'am.
board?
No, ma'am.
Can I finish my question?
Sorry,
Because you
sorry.
may be anticipating a different one. You understood as a member of this board that you needed to establish whether there was commercial value in the contract. Is that what you're saying here?
No, I'm saying here that I believed, based on his representations, there would be value in this contract.
It's not clear to me that that's different. You describing to me the source you went to, I'm asking an earlier question. Do you agree that you needed to go to determine whether there was commercial value in the contract?
You had to apply your mind that there was some form of value in this contract.
Indeed. So let's look at what you relied on.
Well, I'm sorry. I just want to make sure I understand your evidence. Ms. Hofmeyer asked you the question whether you were saying here in your affidavit that it would be necessary to establish that there was commercial value to the contract. You gave a response which I understood to be affirmative.
Yes, you had to apply your mind to see there is some value in this contract, Chair.
Yes. Now, that to me seems to be different from what you were talking about earlier on when you said, I thought we should ratify this contract because otherwise we may be facing litigation for damages. When you talk about commercial value to the contract, it seems to me you are talking about, if you look at this contract, you're talking about saying, if you look at this contract, is it worth us continuing with it on its own? Leave out the threats of litigation. That's how I understand what you are saying. Am I correct?
No, sir, I'm applying both of them, apologies.
Yeah.
I'm saying one of my reasons was to ratify because we don't want that loss. The second element is, well, what value is there going to be? And Mr. Machala explained some of those values which in my mind were reasonable to get value from this contract. What the rand amount of the value, I did not answer, but it did seem there is value in this contract, sir.
Okay.
I hope I answered that.
I understand your answer.
Mr. Pamensky, let's look at what you drew from Mr. Majila's representations, because you set that out in the sub-paragraphs of paragraph 32. And just the lead-in, you say, in his representations, Mr. Majila explained the value which Eskom had and would continue to derive from the contract. And then you highlight the ones below. Are these the ones that you took into account?
First of all, ma'am, I took into account that they had got this value, which meant that there was existing value that they had been obtaining. So it said there had been. As I said in my affidavit, I found it as a renewal. So they were obviously getting value from before, and management and everybody were happy. So I saw that as one element. And the second element, yes, I understood from his points here, is the value that you would obtain from the sponsorship.
Thank you. Let's take each of them. 32.1 said that Mr. Majila had recorded that similar contracts had been in place between Eskom and TNA regarding the same subject matter, and that contract had come to an end. Mr. Majila did not disclose in his representations that those previous similar contracts had themselves been irregular, did he?
No, he did not.
If he'd done so, would you have been a bit more skeptical?
Very much so, ma'am.
At 32.2, you record that according to Mr. Majila, the agreement offered a platform to Eskom to propagate its various campaigns, including the publicized 49M campaign, which reportedly was a phenomenal success. I think that's a direct quote, actually, from his representations. What did you understand that to convey?
convey that this platform has been very successful to communicate out there with the public on the 49mm campaign. He also said it is, I'll just go to it. He also said, sorry ma'am, if I may go, maybe I've referred to it, it's just come to my mind.
You'll find his representation starting at page 174.
He said on clause 14 on page 4,
sorry, just for the
sorry.
record, it's paginated page 176.
Sorry, it's 176, which goes into 177, and I'll read the last paragraph. The CE believe this investment worth making, having regard to the reported success of utilizations of these platforms in the past.
Right. Mr. Pamensky, again, what Mr. Majila did not disclose in those representations was that the Parliament had requested Eskom to respond on this very question. What value had you been able to extract from the business breakfasts? And the advice that came back from the independent agency that Eskom used at the time was that there was no way to establish a direct causal link between the 49M on the screen at the business breakfasts and the success of the 49M campaign. He didn't include that in his representations, did he?
No, he did not, ma'am.
And if he had, would you have been more skeptical?
Of course, ma'am.
And then you go on to list the rights that would be granted by TNA to Eskom. That also comes from Mr. Majila's representations. Is that right?
Yes, ma'am.
Now, Mr. Pamensky, we've already identified that at the time that you make this decision, you're not aware that the previous board has actually determined that this contract did not have good value for Eskom, correct?
That is correct.
And at this point, am I correct in understanding that the source of your comfort that there was commercial value in this contract lay in Mr. Majila's representations?
Not solely in his representations.
In what else?
In what else? That this came from management, board and management, that they were happy to continue with this, so they must have believed there was value in the contract. Otherwise, they wouldn't have submitted this round-robin resolution to us.
Well, why would you draw that conclusion? You made the point earlier that amongst the people who were asked to approve were the financial director and the CEO, correct?
That is correct.
The round-robin resolution was circulated by the chairman, is that correct?
That is correct.
So why did you make any assumption as to management being behind it prior to anyone in that position having voted on it?
Because management would submit these type of round-robins. It's management's job together to inform us of this information.
But it wasn't circulated by management, it was circulated by the chairman of the board.
I believed at that point in time that we hadn't had one before, but the chairman, the company secretary, sends it on behalf of the chairman and the round robin to do with management at that point in time.
On what basis did you hold that belief?
On the belief, when I used to do round robin resolutions in our entity, we as management were happy to submit a round robin resolution provided there was sufficient information to make an informed decision.
It's now the 3rd of February 2015. Why did you think that that would apply in Eskom?
Because it's just reasonable that they came across in this element, and I assume that's how it works in our organisation. It would work in that organisation as well.
But you do accept that they were asked for their own approval. It wasn't as though this came as a resolution, as some resolutions do, that say supported by management, or this is management's round-robin resolution that's coming to the non-execs on the board.
I accept that, ma'am.
Let's go back to the part of the reliance that you placed on Mr. Majila and his representations. I fully understand it's not the sole source of your comfort that there was commercial value, but I'd like to focus on the reliance placed on Mr. Majila's representations.
Yes, ma'am.
You've already testified that you didn't buy Mr. Majila's interpretation of the contract, correct?
That is correct.
You've also testified...
Sorry, ma'am, I didn't find it improprietary. I said myself, I didn't buy into it. I didn't find anything sinister or anything wrong with his interpretation, but I did not buy it in my mind.
Understood. You also clarified for us that you were aware that the lawyers had advised that he had been involved in financial misconduct, correct?
That is correct.
You also have testified that you were aware that both the SNG report and the legal review indicated that Mr. Majila and Mr. Treyu played a part in removing the termination clause from the contract. Is that correct?
I found Mr. Chow had removed the clause. I didn't find the element that the acting CEO removed the clause.
Well, he signed the contract with the clause removed. At least that is clearly established. Do you accept that?
No, I definitely accept that, ma'am. I'm just saying what the opinion said was Mr. Chow removed that clause.
Let's be clear about the significance of that removal of the clause. Would you agree with me that it's precisely because that clause was removed that this issue was arising at all for the board's consideration?
100% correct.
Because if that clause had remained, on 30 days written notice, Eskom could have got out of the contract.
Correct.
I want to ask you, in the context of those features of Mr. Majila's role in this contract and its conclusion, it was reasonable for you to rely on his estimation of its commercial value?
Yes, I was comfortable on that basis. First of all, there was no impropriety. Second of all, he had a different interpretation that I didn't buy into, but it wasn't sinister or anything to that extent. And I didn't see anything sinister into that extent. So I took it on face value, what was there.
Did you make any inquiries about other contracts of Eskom's in which such termination clauses either appeared or didn't appear?
No, I did not.
Do you not now think it might have been relevant to ask that?
I do think now it would have been potentially relevant to ask that, but it depends on the situation or the circumstances we find ourselves in when that comes. Remember, we're independent, non-exec day-to-day with an oversight, so we'd have to oversight to see that would come in.
If you had asked, you would likely have been given the answer that Mr. Pretorius gave this commission, which is that these were always standard clauses in sponsorship agreements. And I suspect his answer might have resonated with you because he explained why that was so. He said at this time in Eskom's existence, it's in a financially precarious position. Media spend is a nice to have in such an organization. So you don't commit to 43 million rands worth of media spend unless there's some way for Eskom to get out of it if it's not a priority at a point in time. Would you have found that compelling?
Yes, I would have found that compelling.
Mr. Pamensky, if we can then go to page 15 of your affidavit. And so I can be clear on your evidence, notwithstanding Mr. Majila's role in removing that, in being party to a contract in which that termination clause was removed, as well as the findings that he had engaged in irregular expenditure and financial misconduct, you found it reasonable to rely on him as the source for commercial value in the contract.
Ma'am, as I said before, I didn't find anything sinister. These misconducts and these elements you talk in relation to PFMA, and that he breached his he contravened his delegation of authority by entering into this contract, which he interpreted as an investment. So I didn't find anything sinister in relying on his representations here.
Mr. Pamensky, I put it to you that that is an unreasonable position to have adopted, and I say that so that you can give any response you wish.
I don't agree with it, but we'll leave it there.
Thank you. At 34 on page, 33 on page 15, You say there, I therefore concluded that the contract was effectively a renewal, except on more favorable terms. How did you come to that conclusion?
There were two elements. First of all, in the SNG report, it explained that they were saving the 17%. And I just want to stand to correction, it could have been in sorry, let me call him the acting CEO's representation. I just want to check it.
Yes, he did make that
He did.
point.
So that's where I came, and it was quite specific. They were saving 17%, with roughly about 6 or 7 million rand.
Thank you for that. What I was actually interested in, but I should have been specific, is why you regarded it as a renewal.
Because if you go to his element and how they explain it, that they had a media agency, it was from the past, and therefore it was a renewal in that sense. So it was from past, and he indicated it was a renewal by saving that money. And obviously from a sense, as if they had prior contracts with the media company, the media shop, sorry, and if that media shop was no longer doing it, TNA approached, as I understand in here, probably directly, I don't recall that, but you were saving that money. So I concluded it was a renewal, but I also read it, and that's how I interpreted the representation from the acting CE.
Mr. Pamensky, it may well be that I have missed it, so I'm
Okay.
going to ask for your assistance on that.
No-
And no doubt my learned friend will assist if neither you nor I can find it. But where does Mr. Majila talk about this contract being a renewal?
He first of all says that, I'll tell you now. Clause 9.1 was the first one. Previously, there were contracts in place between Eskom and TNA regarding the same subject matter, and that the contract had come to an end. That's how I interpret it, ma'am.
Oh, so
And
we're
then
agreed.
the second, sorry,
carry
second
on.
one was the latitude to engage directly with TNA, as opposed to going through the media shop, who Eskom appointed agency for the placement of advertising related spend, close brackets, offered Eskom the opportunity to save 17% in the agency fees. So it was a renewal of the prior contracts that they had run before.
I understand. You and I are agreed he doesn't use the word renewal.
No, he doesn't use the word renewal.
And the reason why I probe it further, Mr. Pamensky, is that the last contract, in fact, came to an end back in 2012. You didn't have that information. I accept that. But it's interesting to me that you read 9.1 nonetheless to suggest that this is just more of what happened previously.
Yeah, they're extending their contracts and they're extending the sponsorship, and it's been a success to them.
The evidence before the Commission has explained quite clearly why there was that gap prior to this contract. I accept that you weren't aware of this at the time. Had you been told that the reason why there was that gap was because it was having a bad reputational impact on Eskom, can I take it you might have approached what Mr. Majila said differently?
Yes, correct.
Thank you. If we then go back to page 15,
Yes, ma'am.
I want to pick up at paragraph 34 on that page. It seems in some sense to be your summary paragraph of your ultimate decision to ratify this contract. Could you give us in your own words what the fundamental justification was for you in ratifying the contract?
Sorry, ma'am. I took all the points into consideration when I ratified this. This was just one of the points that explained more my mindset to ratify the contract, because management time and attention, and the board for that matter, needed to be focused on these matters. And I interpreted the legal opinion to say there was not a high probability of a success of a litigation at that point in time. And where we as a country were finding ourselves with the load shedding, etc., I believe that the board and management time is better focused on those issues, ma'am.
I accept that the legal review presented two options to Eskom. It was either cancel the contract or ratify it and proceed with it. As I read the review, that's a product of the two questions that were put to the lawyers. Do you have the same understanding of it?
I need to reread it and check it again. I can't say that. What I understood from my mindset was that the lawyers had indicated there were two options to take in terms of the TNA contract.
Let me, in fairness to you, take you to where I derive that from. It's at page 181 of MM3. And if you pick it up there at paragraph 1.2, you'll see there that what Ledwaba Mazwai is doing in this paragraph is identifying the view that they've been asked to express on the questions posed. Do you see that?
I see that, ma'am.
And what are those three questions that they were asked to
You are correct
answer?
on your last question. They were asked what corrective action to be available to be taken pursuant in respect of the acting CEO on the one hand and Mr. Chawa on the other, whether the rectification of the contract is an option available to Eskom, and if so, what are the implications of ratifying the TNA contract would be, and whether cancellation of the TNA contract is an option available to Eskom, and if so, what are the implications of cancellation of the TNA contract?
Mr. Pamensky, I readily accept that you're not a lawyer. But it's relevant to know what was or was not put to the lawyers for their determination, and what might have been relevant to the board when it was making this decision, had these options been disclosed to it. If you had been told that there was actually another option available to Eskom, a legal option, not to cancel or to ratify, but to review the conduct that had precipitated this contract so that it wouldn't be required to be bound by it. Is that something you would have wanted to take into account?
If that was there, one of the options I definitely would have taken into account if they included that element.
Thank you. And then if we go back to page 15, you say at the bottom of that page, you did not discuss the TNA agreement or my decision to ratify it with other members of the board before doing so. You say, I was satisfied to take the decision on the documents made available to me. Do you see that?
I see that.
You go over on the
Sorry,
next page.
Sorry, ma'am. Also, while I was comfortable, there was sufficient information. We received a legal opinion. We received an audit report. In my mind, at that point in time, there was sufficient information for us to make a decision. I had no reason not to believe the lawyers, the auditors, our chairman, and any of the other board members at that point in time, ma'am.
Chair, what I want to go to now is really the concluding aspects of Mr. Pamensky's affidavit,
Yes.
and the point that he picks up over the page at 16 about the way in which this decision was taken by round-robin resolution. I don't anticipate a great deal longer in his evidence, but we're in your hands insofar as taking the break now, returning afterwards.
Yes, how much time do you think you need?
I suspect 30 to 40 minutes.
Okay, maybe maybe we should take the lunch break in that event, and then we'll return at 2 o'clock, and then you can then we can try and wrap up.
Thank you, Chair. I also
Yes.
understand my learned friend may want to ask some clarificatory questions in re-examination, so that will also facilitate
Yes.
us returning.
Okay, right.
But, sorry, there is one matter that my learned friend keeps reminding me about today, and I forget. One of the witnesses, Mr. Jackson,
Yes.
was summoned to appear today and has been present.
Yeah.
There's no chance that we would get to his evidence today, and so may I
Yes.
request that he be released?
Yes, no, I think he can be released, but I must just mention for the benefit of counsel for Mr. Pamensky that I indicated earlier to the Commission's legal team that we might not be able to sit the whole day because I'm not too well. But I would assess the situation as we go along. So we will see when we come back after lunch, and it would depend whether Ms. Hofmeyer is able to finish within a certain time, and whether whatever re-examination you might wish to have, how much time it might require.
I'm not a believer in lengthy re-examination.
Yes.
It's for clarification only.
Okay.
So I imagine
okay,
if Ms. Hofmeyer is within the 30 to 40 minute period
Yes.
concerned, I'll be something like 10 to 15 minutes at the most.
That's a good indication. No, thank you. Okay, let's take the lunch adjournment. We'll return at 2 o'clock. We
Thank you,
adjourn.
Chair.
All rise.